interestingly, the next issue also came by on the fact about the role of the official liquidator. Now, the official liquidator is an officer who is appointed by the government to take about liquidation processes of companies. And the official liquidator actually is somebody who is appointed by the government but is answerable to the court in terms of the liquidation processes that are generally undertaken for those companies that are sick and who cannot be revived in terms of their business and operation. Now, interestingly, on the question of whether the office of the official liquidator is a public authority, obviously the issue was because there was a denial, and the official liquidator refused to give information under the RTA Act, and hence the case comes before the CIC in the year 2008 in this case called Namita Kumar versus the official liquidator. Now, when you look at the official liquidator, he is somebody who is appointed by the government and works under the direct supervision of the High Court. And you will notice that the salary and allowances to the official liquidator are actually paid by the government. Interestingly, the official liquidator is a statutory appointee, and the government is bound to look at the appointment where the court consider it's necessary to do the same. And hence, in these circumstances, when the appointment is by an organ of the government, when the salary and allowances are paid by the government, and there is the sense of responsibility that an official liquidator discharges representing the government and also as an officer of the court, it was quite obvious for the CIC to come to the conclusion that the office of the official liquidator is a public authority under the Right to Information Act. So it's not only the judiciary that is brought within the scope of the Right to Information Act. It is something that we will see how the judiciary was brought in. But I think those agencies that help the functioning of the judiciary, like the official liquidator, are also agencies that are held accountable under the Right to Information Act and have been declared as public authorities as well. Similarly, you will notice that the question that arose was whether the Attorney General's office is a public authority under the Right to Information Act. Now, you know that there is the state where you have the Advocate General and there is the center where you have the Attorney General of India. Now, interestingly, under Article 76 of the Constitution of India, the President shall appoint the Attorney General of India, right? This is something that is provided by the Constitution. It also further stipulates that the Attorney General is the main advisor to the Government of India in all legal matters. Rather, he is the first legal officer to the government, and he does provide legal advice to the government from time to time, and he may also have to advise the President in his discharge of functions from time to time. Now, the Attorney General of India, in short we generally abbreviate it as AGI, he represents the government of India in court and its proceedings. He has the right to audience in all courts throughout the territory of India, and he takes part in legal debates. He defends the government, and you will notice that his position is that of a very important position, because he is somebody who represents government actions, defends them in the court of law. Now, what happened in this case was, it's a very interesting case. Somewhere in 2011, November, an RTI activist by name S.C. Agarwal, he's a very prominent RTI activist, filed an RTI application to the AG's office seeking certain information. Unfortunately, the AG's office declined to accept his application, claiming that there was no CPIO appointed. Thereafter, S.C. Agarwal filed a complaint before the Central Information Commission, and the Central Information Commission in December 2012 held that the AG's office is a public authority under Section 2H of the Right to Information Act. At the same time, another RTA applicant by name R.K. Jain also made a similar application to the AG's office. This was in 2013. This was after CIC had held that the AG is a public authority. right? So in 2013, when R.K. Jain sought certain information from the AG's office, the AG's office responded saying that the AG is not a public authority, right? So there was denial, and a writ petition thus was filed seeking the declaration of AG's office as a public authority in the High Court. Now the single bench of the High Court, this was Justice Vibhu in the Delhi High Court. The learned judge in a judgment dated 10th March 2015 declared that the AG's office is a public authority under the Right to Information Act. And to state from the judgment, it said something like this, that the office of the AG is an office established under the Constitution of India. The incumbent appointed to that office discharges functions as provided under the Constitution. Article 76(2) of the Constitution expressly provides that the AGI would perform the duties of a legal character and also discharge the functions conferred on him under the Constitution or under any other law in force. So having got or derived powers under the Constitution, having the appointment conferred under the Constitution, it was inevitable for the Delhi High Court to have declared the AG's office as a public authority. Interestingly, you would notice that this was also challenged before the divisional bench of the High Court, which initially stayed the matter, and then finally it overruled the same matter, and it was denied that the AG is a public authority by the divisional bench. So the AG's office was exempted from the purview of RTI through a judgment that was delivered on Feb 3rd, 2017. Later on, S.C. Agarwal filed a special leave petition in the Supreme Court in March 2017, and the Supreme Court had to decide finally whether the AG's office comes within the purview of RTI Act or not. It was contended in the Supreme Court that apart from Article 76 in the Constitution, there are privileges and functions under Article 88 of the Constitution that the AG had. For instance, he had the right to take part in the proceedings in the Parliament. He also performed certain statutory duties under the Contempt of Court Act 1971. And hence, it was contended that the AG be brought within the domain of the public authority. However, it was contended on behalf of the respondent that the functions performed by the AG do not alter the rights of any person, or nor do they bind the government of India. That means the advice of the AG is not binding on the government, but the government may either follow it or not follow it, and hence it should not be construed as an authority, right? And the AG's office does not have the necessary infrastructure to support the applicability of the RTA Act. This was a very strong argument that was made, and the AG is generally a single person, or it is a single person's office that is designated as an AG, and you cannot have an appellate authority within the AG itself. So the AG is generally a lawyer, and above him there is nobody else within his office or within his organization. So I think these were certain arguments that were made as against the issue of holding the AG office as a right to AG office as. So I think the matter currently as we stand is probably pending and is left for final adjudication as well.